The Fourth Amendment to the United States Constitution is a crucial part of the Bill of Rights and was ratified on December 15, 1791. It addresses the protections of individuals against unreasonable searches and seizures by the government and establishes the requirement for warrants based on probable cause. Now, in my opinion, this amendment is violated the most by almost every agency, including cops. You see, to bring some text here, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. To bring more context, right to be secure. The Fourth Amendment protects the right of the people to be secure in their persons, houses, papers, and effects, emphasizing the importance of individual privacy and security against arbitrary government intrusion, unreasonable searches, and seizures. The amendment prohibits unreasonable searches and seizures, but it does not define what is considered unreasonable. This has been the subject of extensive legal interpretation, often balancing law enforcement needs against individual privacy rights. Remember that. That is key. Warrant requirement. The amendment establishes that warrants may only be issued upon probable cause, meaning there must be sufficient evidence or reason to believe that a crime has been committed. The warrant must also be supported by oath and affirmation, usually provided by law enforcement, and must particularly describe what is to be searched or seized. Probable cause. This is a key legal standard that has been further defined through case law. It generally means that there is a reasonable basis for believing that a crime may have been committed or that evidence of a crime may be found in a particular place. Legal cases and interpretations. The Fourth Amendment has been the subject of numerous landmark Supreme Court cases that have shaped its interpretation, including Mapp versus Ohio, 1961, Terry v. Ohio, 1968, Katz versus the United States, 1967, and Mapp versus Ohio established the exclusionary rule, which prevents evidence obtained in violation of the Fourth Amendment from being used in court. Terry v. Ohio. And because of Terry v. Ohio, they are able to check us, stop us. This is the entrance of them invading our privacy and intruding upon and infringing upon our rights. This, Terry v. Ohio, to me, in my opinion. Terry v. Ohio allowed for stop and frisk procedures based on reasonable suspicion, a lower standard than probable cause. See that? Katz versus United States expanded the scope of the Fourth Amendment to protect individual privacy in places beyond just one's home, introducing the concept of reasonable expectation of privacy and some modern implications. In the digital age, the Fourth Amendment has been invoked in debates and legal cases involving electronic surveillance, data collection, and privacy rights. Issues such as government wiretapping, GPS tracking, and access to electronic communications have raised new questions about what constitutes an unreasonable search or seizure. Overall, the Fourth Amendment remains a vital safeguard for individual liberties, serving as a check against the abuse of government power in criminal investigations and other forms of surveillance.